the property management industry, fair housing offenses are considered especially troubling. In the United States, a dedicated fair housing attorney, Leslie Tucker, provides case explanations and best practices. These are some cases.
Hello, everyone, and welcome back to Case Files, the show where we explore real fair housing cases so property management professionals like all of you can learn from what went wrong and avoid costly mistakes. I'm Jonathan Saar, and once again joining me is fair housing attorney Leslie Tucker. Welcome back, Leslie. It's good to see you.
Yeah, you too, Jonathan. Thanks. It's good to be here. And today we're doing a follow-up from a case that we had discussed previously. We previously discussed the case of Dr. Emma Adams, who alleged that she was denied a reasonable accommodation for an accessible parking space at her condo complex. Since we last covered this case, the parties reached a settlement and wanted to talk about what that resolution looked like and what it means for housing providers.
Very cool. Yeah, nice to be able to look back at a case and give everyone the connector part, how it turned out. So let's remind everyone, Leslie, if we can just take a minute, go through like the key facts. So we've got Dr. Adams, who is a paraplegic, drives a van, specially equipped with a motorized ramp. She was assigned a standard parking space by the property, which did not give her enough room to enter and exit her vehicle. She had made multiple requests for an accessible parking space, which were allegedly denied multiple times over the course of a 3-year period. So that's what led the United States to file a complaint on her behalf under the Fair Housing Act.
Right. And the lawsuit alleged that the HOA and the property management company violated the Fair Housing Act by refusing to reasonably accommodate Dr. Adams' disability-related parking needs. The complaint does state that they did take a few actions on her behalf. For example, they did give her access to all of the levels of the parking deck to give her a better chance of finding an open, accessible space. And they also reiterated to all the residents about the restrictions on parking in an accessible space and who can do it and for how long. But ultimately, HUD found that these actions that were taken were insufficient, and they found reasonable cause to believe that a violation had occurred. And as you said, this lawsuit resulted. The court later granted partial summary judgment in favor of the United States, which established the failure to accommodate part. But regarding the remaining claims that were open, the parties opted to settle.
Okay. Very good. So good overview, good review of the case in general. So let's dive into the outcome. What did the consent decree require?
The consent decree, which is what resolves the case without a full trial occurring, imposes several obligations on the owners and the management company. Notably, they must permanently assign a specific parking space to Dr. Adams for as long as she lives at the property, one that actually works for her.
Right.
And the space will be marked just like other resident assigned spaces, meaning that they have to take off all of the markings, the stripes and all the markings on the space so that other residents don't mistake it as an accessible space that's open to everyone. So that was part of the agreement as well.
Okay. But it's not just about the space. There were other requirements about handling future accommodations, correct?
Of course. The resolution also includes mandatory fair housing training for the board members, employees, and agents involved in management. They have to adopt and distribute a clear accommodation and modification policy, which is very common in these agreements. They have to post signage about how to make an accommodation request, right? So there's no confusion for residents on how to do that. Mm-hmm. And they have to keep records of all future requests.
Okay. So how's it going to be monitored then?
Well, there is certainly a stringent monitoring requirement. The housing provider has to not only keep records, but submit annual compliance reports to the Department of Justice. So when, who was trained, when they were trained, send records of accommodation requests and what happened with them. And of course, they have to disclose any new discrimination complaints that they receive.
Got it. So next question. How long does the property have to continue with these monitoring requirements?
The consent decree is open for 3 years, which is a pretty common time period for these types of agreements. So during that time, the defendants will have to continue to provide monitoring updates.
Okay. So what our audience always enjoys is, how does this apply to me? What can we learn from a case like this? So let's talk about some takeaways. There's a lot of critical lessons in this case. What's your number one takeaway?
I think it's that you should not ever delay or ignore requests for accommodations. If you're unsure about the documentation or the scope of the request, it's your obligation to seek clarity, to respond, to engage in the interactive process. So in this case, the delay alone became a large part of the basis for liability.
Okay. And it sounds like, based on some of your comments, that training and written policies also played a huge part in the settlement.
Definitely. And it is very common in these types of settlements for training and written policies to be involved. Compliance starts with education. For example, many housing providers believe that they are not allowed to assign an accessible parking space as an accommodation, which seemed to be the case in this case as well. But I hear it from clients a lot. This is simply not accurate. So ensuring that your staff is aware of their legal obligations is really crucial.
Okay. Thank you. Great takeaways. I know our community appreciates very pointed education. That's what this channel is all about. So to everyone who's listening, number one, thank you for being awesome guests and consumers of this channel. We appreciate you a lot. If you've already seen our original coverage of this case, we hope this gives you some closure and clarity in how fair housing complaints can turn into formal enforcement. If you're new, go back and watch the first episode to understand how it all began, and we'll make sure there's a connecting link in the show notes so that you can check that out.
Right. So this particular story certainly didn't end just with the complaint being filed. It ended with this consent decree, this binding agreement that ended up changing the way the property's managed, and certainly protected the rights of the person with a disability.
Yeah. Very nice. Thank you so much, Leslie. And thank you everyone for tuning in. Stay compliant, stay informed, and we'll see you on the next episode of Case Files. Take care, everyone.